Sean, take one.
Dan, thanks so much for being here as part of our video series on trial lawyers as storytellers, inspired by the firm's sponsorship of Inherit the Wind at the Goodman Theater. So trial is theater, and cross-examination is also a time when you're not only poking holes at a witness, but also telling your story. How do you think about putting together an effective cross-examination from a storytelling perspective?
Cross-examination is the single most important point of performance of advocacy that you have as a trial lawyer. And it's also the most difficult, and it's the most perilous, because you can fail in cross-examination. That requires enormous preparation. You can only do so much on cross. You may have 22 things you want to do, but you want to do 6. And then once you decide those 6, you have to say to yourself, what is the order that I'm going to put these in to tell a story that's going to prevail? Because cross-examination follows direct exam by your opponent. If your opponent has done a good job, you are in a hole. You're in a grave. The first line across has to score. If you got 6 lines across, start with the strongest line across you have and the one that you know damn well will score. And normally, that first line across, I may spend hours on what takes 6 minutes, 8 minutes, where I've futzed around with the questions, I prepared them, I edit them, I re-edit them, I rehearse them with the team, and I do it in a way to lay a trap so that I will, at the end of 6 minutes, my head is at least out of the grave. And I've earned the right to continue, because if you fail in those first 6 or 8 minutes, there's no need to keep going because you're not coming out of the grave. It isn't going to happen. During a cross, I am so thoroughly prepared. In modern litigation today, with depositions, prior testimony, I pretty much know what every answer is going to be. If I cross a witness for, say, 40, 50 minutes, and that witness knows every time he goes off track, I smack him. I learned to smack him because I got a transcript or some point to make, and he's going to lose and I'm going to win. And so when I get into a point where I'm not as strong on, I want him to have already been trained like a SEAL to kind of follow me down the path. He won't give me everything, and it doesn't always work out. But by that point, I've been up there 45 minutes. If I lose a point or don't score heavily, I'm okay as long as I left one last point as a crescendo. I have to end on another winner. May not be as strong as point 1, but I have to sit down as a warrior that won. I can't be defeated. And so that last line across also can never fail.
So let's talk about closing argument. Now you actually get to argue. You get to draw all the threads together. How do you approach a closing argument?
During the trial, as I'm watching witnesses or watching proceedings, listening to what's going on, I get visions of the closing argument that prance into my head, and I make notes to myself. And I just draw down random notes, and I put them in a folder, and I number them. Because in a long trial, maybe 3-4 weeks or 3 or 4 months, at the end, I go back through what could be a pretty good stack of notes where I had inspirations and ideas. And it's amazing that those thoughts that kind of funnel up through your mind, I find a way to work a lot of those into what I'm going to do in closing argument. When I prepare the closing argument itself, I'm a big believer in thorough preparation. I dictate every word, I prepare, everything's typed out, I don't leave anything to chance, and I have a script of everything I want to say, exactly how I want to say it. And then I memorize it, because I will not use any notes in front of the jury. I go to the podium, and I want to be notes-free. I want the jury to think I'm talking to them from my heart, extemporaneously. When I see lawyers read from prepared text in closings, I want to go up and just grab them and say, you can't do that. Not in front of a jury. You got to speak like you're talking from your soul, okay? And you can't be looking down at your notes. You got to know what you're going to say. But if you work hard enough and you prepare it, you script it out, and then you rehearse it over and over again, by the time you get up, You may not say it exactly the way you planned, but it's pretty damn close. And by the way, the one thing I should have put in there, all that work is not just done by me, it's a team. I'm just telling you, the young lawyers that I have the privilege to work with at Winston, that have learned what they call the Webb method of doing opening, closing, direct, and crosses, they're the ones that are doing enormous amounts of legwork for me, where they're pulling everything together, and then they're giving me drafts of scripts. I do a lot of edits, we work on it as a team, but the reason I think we're such a successful law firm in actually trying cases in America is that we have more first chair jury trial lawyers at Winston than any other major law firm in the United States, because we do try jury cases. We're known in the marketplace for trying jury cases. And one reason why we're successful is not the Dan Webb or the George Lombardis, it's the younger lawyers coming up through the system that get inspired to work so hard that eventually will grow up to do what Webb does. And I think it's a great system.